feeble attempt at using my phone as a gavel because I'm without a gavel tonight. Good evening, everybody, and welcome to the monthly meeting of the Arlington Board of Zoning Appeals, which is also known as the BZA. My name is Charles Smith, and I'm the chair of the board right now. Now, this board is made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Judy Freshman to my immediate left, Vice Chair Inta Malice to my immediate right, Paul Melnick to my far right, and Peter Owen to my far left. Also present are professional staff, including Stephen Rissy, the coordinator, and who serves as our secretary to my extreme left. And let's see, Cliff Hogan we have before us. We have Mark Hamela also with us, Jacque McNeil, and Pamela Banner, a new staffer in the office who is joining us and working with the staff tonight. Thank you all for being here. I want to extend a warm welcome to you. These are not the most exciting meetings, but they certainly benefit by dint of by citizen input. Now, to avoid disruptions, I'd ask that you turn your cell phones off or put them in a silent mode. On the front table, you will see a series of reports. There's one report for each case, which is on the agenda tonight. If you haven't had a chance to see your case, to see your report, take an opportunity to look at it, and then return that report to the front table so others who might have an interest in looking at it can also review it. Now, our powers are prescribed in the Code of Virginia and are set out in further detail in the county's zoning ordinance, which is adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations which are set forth in the ordinance. That authority rests solely with the county board. This board does have the authority to do 3 things, and tonight we'll only be involved with 2 of them. The 3 things are: we can approve use permits that allow modifications of placement requirements for structures on 1- and 2-family lots where there's no option in the zoning ordinance to allow such modifications. Number 2, we can grant variances from the specific requirements of the zoning ordinance. And third, we can decide appeals of decisions of the zoning administrator, of which there are none before us tonight. Now, when approving use permits, the Board of Zoning Appeals may impose conditions that we deem necessary and in the public interest, including limiting the duration of the use permit. Now, in order to approve use permits, the law requires that we find that the proposal will meet conditions and that the permit will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plans and land use and zoning related policies of the county. Now, to do this, the Board of Zoning Appeals shall consider whether the modification will promote compatibility of development with the surrounding neighborhood because the structure's overall footprint, size, and placement are similar to the structures on property surrounding the lot in question, and whether the modification will help preserve natural landform, historical features, and/or certain significant trees and foliage. Now, when granting variances, the burden of proof is on the applicant to prove by a preponderance of the evidence that it meets the following criteria. The strict application of the ordinance would unreasonably restrict the utilization of the property, or that granting the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon at the time of the effective date of the ordinance, or that the granting of the variance would alleviate a hardship by granting a reasonable modification to a property or improvements thereon requested by or on behalf of a person with a disability, and the property for which the variance was requested was acquired in good faith and any hardship was not created by the applicant, and that the variance granted will not be of substantial detriment to adjacent property and nearby properties in the proximity of the geographic area, and that the condition or situation of the property concerned is not of so general or recurring a nature as to make reasonably practicable the adoption of an amendment to the ordinance, and that granting the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property, and last, that the relief or remedy obtained through the variance is not available through a special exception process as provided for under the zoning and or subdivision ordinances. Now, when deciding appeals of the zoning administrator, the board must use its judgment to determine if the administrator was correct. This evening, cases will be called, and a brief staff report and recommendation will be given. Following that, board members will ask any questions of the staff which we may have. Next, applicants or their representatives will be given an opportunity to make comments to support the application or appeal. If they choose to make a comment, they must come forward to the podium so that their comments can be recorded for the record. Next, all speakers for the item will be called. Speakers must fill out a speaker slip, which is available at the corner of the dais up here, and turn those in before the case is called. And after hearing from speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may ask questions of any speakers, but does not permit, and we won't condone any cross-examination or direct questioning by others. We've deemed the following time limits for speakers to be sufficient. 20 minutes for applicants of appeals, 5 minutes for applicants of use permits and variances, which we have deemed 3 minutes for representatives of organizations and 2 minutes for individuals as sufficient. After the board has gathered all the information we need and discussed the case, we'll decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you're welcome to stay for the balance of our session or leave at your convenience. Again, thank you all for being here, and I'd ask Mr. Rissy to please call the first case.
Case number V-11463-19-UP-1 is a use permit request by Kathleen McCowan, the owner, to permit a left side setback of 8.3 feet to the wall instead of 10 feet as required from the side property line, and to permit a rear setback of 19.5 feet to the wall, 18.5 feet to the eave instead of 25 feet to the wall, 21 feet to the eave, as required from the rear property line, regarding a two-story rear addition on a non-conforming semi-attached two-family dwelling in the R27 zoning district, premise known as 2021 21st Street North. Staff recommends the board adopt the proposed motion to withdraw the subject use permit request per the written request of the applicant.
Thank you. Are there any questions, Mr. Rissy? Hearing none. Ms. Freshman?
I move the Board of Zoning Appeals withdraw the application for the use permit requested in case V-11463-19-UP1 from the BZA consideration per the written request of the applicant.
Second.
Thank you very much, Mr. Owen. It's been moved and seconded that we accept the withdrawal of this case. Any other comments? Hearing none. All in favor of the motion signify by saying aye.
Aye.
Aye. All opposed? The ayes have it, and this matter is withdrawn. Thank you. Please call the next case.
Case number V-11473-19-UP-1 is a use permit request by G. Lincoln and Layla McCurdy, the owners, to permit a right-of-way setback of 6.2 feet to the carport, 6 feet to the carport eave, instead of 25 feet to the carport, 21 feet to the carport eave, as required from the 21st Street North right-of-way, regarding the proposed detached carport in the R8 zoning district, premise known as 5425 21st Street North. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions. And I'd like you to please note that there is supplemental material for this case that came in after the application packet was assembled and printed. It is some additional signatures of support from the applicant.
Thank you very much. Thank you for noting the addition of supplemental materials. Any questions of Mr. Rissy? Mr. Mellick?
So I needed a clarification. In this case, the petition is referencing a letter from the applicants, except I noticed one letter in the package references 8 feet. Let's see, 8 feet to the carport, and the other one references 6 feet 3 inches. But it actually looks like, the actual staff report says 6.2 feet. So does the staff, I'm just wondering about the letters. Are both letters, is there another letter that's supposed to replace them? Or is one or the other letter the letter we're supposed to look at that's referenced in the petition? Do you know?
I don't believe, I think we're going off of the application, which was for, or the original plans that showed 6 feet 3 inches, which we equated to be 6.3 feet. It came out to 6.26 feet, which we rounded to 6.3. To the carport, and I'm unaware of I think the letters may have been done at a time before the final distance was settled by the applicant, but
Okay.
that could be clarified by the applicant.
Mhm.
Because I do know that there were a couple of revisions before the final application was made.
Okay. All right, thanks.
Ms. Malice?
One small question and then a kind of a bigger issue. In this report, it refers to reported lot coverage or main building footprint. The modifier reported, is that significant?
It's fairly standard language across the staff reports, and it's the coverage that was given to us by the applicants.
Okay, all right. And then the second bigger issue that I think we'll have some discussion about is that staff is equating a carport to a porch.
I would say they're drawing parallels between the two structures, yes.
Okay, well, I think we need to figure that out.
I think we'll have some lively discussion on that matter. Any other questions for Mr. Rissy? Hearing none, Mr. Lincoln or Ms. McCurdy? If you'd like to make any comments with respect to your application, add anything for the record,
Oh.
welcome.
Thank you very much. I want to, first of all, thank the staff who guided us through this process. It's been very, very helpful.
Could you fully identify yourself?
I'm G. Lincoln McCurdy,
Okay,
and my wife and I own 5425 North 21st Street.
thank you.
And we take great pride of preserving a dwelling that was built after World War II rather than demolishing it, and maintaining the integrity of the post-war period of Arlington. But we do have an issue with birds in the neighborhood because the utility lines go across our driveway, and we have bird droppings on our car all the time. And we feel that the design of the carport is going to actually add character to the house and to the neighborhood. And we have consulted with all our immediate neighbors, and they're all 100% behind us. I'll be happy to answer any other questions.
Mr. Chair,
Mr. Melnick,
I have a question.
you've got,
Okay, I don't know if you heard, pardon?
you've got the floor.
Okay, so I had previously asked Mr. Rizzi about the letters, because the petition states, the people that signed it says, I have read Mr. and Mrs. McCurdy's letter dated January 26, 2018, requesting use permit allowing the construction of a carport. And I noticed in the package there are two letters dated January 26, and one references the carport being 8 feet from the sidewalk, and the other, it looks like there's a cross-out and has 6.3 feet. But what I'm wondering is, if you can let us know in reference to the petition, do you know which letter the people that signed the petition, which one did they see? What measurement did that letter have on it?
They saw the first letter, but we explained to them that it was going to be from anywhere from 6 to 8, based on my ignorance.
Okay.
But we showed them drawings of the carport, and no one had any issues about it.
Okay, thank you.
Thank you very much, Mr. Melnick. Any other questions of the applicant? If not, please stand by because we may have additional questions after
Okay,
we
thank you.
discuss this matter. Any further discussion?
I'll go back
Ms.
to
Malice.
my point. Thank you. I don't see a parallel between a carport and a porch. And so it seems like the staff's rationale is based on this being analogous to a porch and having the benefits of a porch that we typically favor. You know, there's reasons that BZA and the county, you know, have allowed extra consideration for porches, and I think that's kind of a well-established principle. Here, it's not a porch, it's a carport. And so, is staff thinking that this configuration would be appropriate in every house in the neighborhood, that we want to go this way?
I think in analogizing the two, staff is just pointing out that both are unenclosed structures with columns or piers supporting a roof. That's pretty much verbatim the definition of a porch. It holds true for a carport as well, that it's an unenclosed structure with columns or piers supporting a roof. So structurally, we find them to be similar. I can't say they function similarly, but from a structural standpoint, they are comprised of similar elements.
Do you feel that the county board and its policies have incentivized carports?
Oh, certainly not.
Carports?
I mean, the language of the zoning ordinance is clear, giving a 3% bonus specifically to unenclosed porches on the front of the structures and no other structures, including carports. Likewise, the zoning ordinance has a list of structures that are given a 4-foot encroachment, including porches, balconies, eaves, trims, fascia, etc. And carports are not included. So we're not saying that they should be. We're not proposing to add them to the list. We just pointed out that structurally they are similar to another feature that is given that allowance.
And so staff's support of the application is based on which features of the application?
I would say that staff's support of the application is based on the comparable other structures that we are able to find with setbacks that were equal to or comparable to what is being requested by the applicant.
Okay.
Thank you very much, Ms. Mellis. Mr. Ricci, any further questions?
Mr. Chairman,
Mr. Owen?
it seemed to me like a great many of the right-of-way setback comparison properties listed in the staff report for this item were somewhat distant from the subject property. Are any of them inside the Terra Leeway Heights Civic Association boundaries?
Yes, 1800 North Harrison is within the Terra Leeway Heights Civic Association boundary. I will point out, however, that the first 5 are not in the Terra Leeway Heights Civic Association boundary. They're in the John M. Langston Civic Association, but they're only about 1.5 blocks outside of the Terra Leeway Heights Civic Association. Both the subject property and those listed are respectively close to the boundaries of their civic associations.
Close to the my impression was that this property was almost smack dab in the middle of the Terra Leeway Heights Civic Association boundary.
So I believe the properties located in the John M. Langston are only about 4 to 5 blocks away from the subject property.
That's true.
Yeah.
But neither set of properties is at the edge of their respective civic association.
I think especially the ones in the John M. Langston are relatively close to.
It's a long, thin neighborhood association, and that street is in the middle of it. Okay. Speaking of the John M. Langston Civic Association boundary, what is the closest parcel to the subject property that has a front right-of-way setback less than 6.2 feet, other than the John M. Langston neighborhood?
Okay, so to answer this, I'm going to give first the kind of boilerplate. I can't say for certain what the closest property is with a setback of less than 6.2 feet, just because we don't have examples of every property. I did note that there was additional properties that staff didn't list, including 1924 Dinwiddie Street, which has a carport, that has a porch that may be close to the 6.2 feet the applicant is requesting. The structure itself, I believe, is 12 or 13 feet back from the property line, according to the plat, and the depth of the porch isn't recorded on that plat, so it's between 6 and 7 feet, and I can't say for certain.
How
what it
far
is.
away is 1924 Dinwiddie? Do we have a map of the neighborhood? Can we go to the tax map? Show
Not
where
on the
tax
PowerPoint.
map it's located?
We don't have the, we only have the locator map in the packet.
This map,
Yep,
does that appear on this map?
it does not.
No. How far away is it from the subject property?
It's approximately 5 blocks from the subject property, so
So
just
far-
a little bit further than the John
Farther
R.
than the ones that you
Winston's.
listed, okay. Are 2625 John Marshall Drive and 6519 27th Street North the properties closest to the applicant's property with carports within the 25-foot setback that you know of, or that you could discern?
Actually, no. So in addition to those two, the address 5101 19th Street North has a carport that the BZA approved to be within the 25-foot required right-of-way setback. That was case V-7441-93-2. It is approximately 4 to 5 blocks from the subject property. It also happens to have walls that the BZA approved to be 11 feet from the right-of-way in case V-2696-65-1. And this is just another example of this was a property that the staff member writing the report was unaware of, and when this question was asked of staff, I did some additional research and found an additional and closer property that has a carport that had its setback reduced and walls reduced even further.
So, I'm sorry, could you list the distances again?
That was 4 to 5 blocks from the subject property.
I'm sorry, the
Case numbers?
the
Setbacks?
amount of the setbacks.
So the carport I just had was within the 25-foot required setback. I think it was 19 or 20 feet, and the walls were 11 feet from the right-of-way.
And going back to Ms. Malice's questions, are you aware of any prior use permit applications before the BZA where staff has compared carports to front porches for purposes of its analysis?
I am not aware of any.
So this may not be the first, but it may be the first.
It may be the first.
Okay. I think that does it for the moment.
Thank you very much, Mr. Owen. Any additional questions?
I would
Ms.
just
Malice.
follow up. I guess I was listening to your exchange, and I was having a little bit trouble figuring out mentally putting them into a chart form. You know, so if we took out all the front porches and all the main dwelling units here in this table that we have, and only referred to carports, what would be on this table?
So if you take out all the front porches and all the main dwellings on the carport, of those listed, we only have 2 carports. That's the 2625 John Marshall and the 6519 27th Street North. In addition to that, I know that I could add the
1924
1924 North Dinwiddie, which
Maybe.
was, again,
maybe.
for the carport, a comparable 1920 feet.
Thank you very much. Any additional questions or discussion? I don't think there is any need to call the applicant back because these really were questions directed to staff and not related actually to the application, but the policies of the county and the kind of the recommendation of the coordinator, or actually the recommendation of Mr. Hamela, the author of the report. So if hearing nothing more, the matters with the board. I too have concerns with regard to the analogizing a carport to a porch. As Ms. Malice outlined, there are long-standing policies that favor porches by the county, and I'm not aware, after a number of years on the BZA, of any such policy with respect to carports. In fact, we've kind of treated carports, generally, there are issues with respect to side yard setbacks with carports. In this case, it's a front yard setback. And from my point of view, it would extend greatly into the front yard setback, such that it would not be consistent with the neighborhood. And I think that the discussion by staff kind of outlines the fact that there are no such comparables with respect to carports. So while I understand the need that the applicants presented for it, in this case, it looks like the sunroom has taken the space that would usually be used for a carport. So with that utilization of that space, going forward, it seems to me to be in direct contravention of what the zoning ordinance allows. And that's kind of my take on it. So I consider the matter with the board. I'd be happy to entertain any motions.
Mr. Chairman,
Ms. Malice.
I find myself in agreement with you on this issue, that it's a precedent that is difficult, that we set here when we do something like this without, really a good substantial basis. I'm willing to move the recommendation.
I'd be happy to take a motion.
I move that the Board of Zoning Appeals deny the application for use permit V-11473-19-UP-1.
Is there a second?
Second.
Yeah, it's been moved and seconded. And I'll simply say to the applicant, I don't think that there would be any modification that you could make to this proposal that would alter the prospect for passage, nor do I think you could make any alterations that would accomplish your goal of creating a carport. If you were to shorten it, it would still encroach greatly into the front yard, and then it wouldn't really serve the purpose of a carport. It would only partially cover your vehicle. I think from the overhead picture, it's kind of apparent. So, hearing no further discussion from the board, all in favor of the motion to deny the subject use permit signify by saying aye.
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 Aye. All opposed? And unfortunately, this matter is denied.
Mr. Chairman,
Mr. Owen?
I just take a moment to note that the applicant, I think, has a well-founded view that his house is lovely, it's well-maintained, it's a good example of preserving an old house.
Yeah.
And the proposed carport is the loveliest carport I've seen proposed at the BZA. So it's a shame that, you put the obvious work into preparing your application and contacting your neighbors. This has nothing to do, as the chairman said, in my view, with anything negative that you were proposing. It's just the law requires us to analyze this in a certain way, and that's what we've done. So I just want to express appreciation for the applicant, earnestness and care in presenting this application.
Thank you very much, Mr. Owen. Mr. Rissy, please call the next case.
Case number V-11474-19-VA-1 is a variance request by Nazfa Sawaz, the owner, to permit a lot coverage of 46.57% instead of 40% as required for a one-family dwelling without a qualifying front porch or rear detached garage in the R6 zoning district regarding a proposed driveway expansion in the R6 zoning district, premise known as 2910 2nd Road North. Staff recommends the board adopt the attached proposed resolution denying the variance. A proposed alternative resolution has been provided should the board see fit to approve the variance as advertised.
Any questions of Mr. Rissy?
Yes,
Ms.
Mr. Chairman.
Malice?
How did, Is there any background to this application, how it came to being, that any special information?
I'll just give the background that I know is the applicant has recently finished the construction of their building, and they're having some issues with the cars rolling over the edge of the driveway that they have, and so they were seeking to expand the driveway to prevent the muddying of the grass, is probably the best way I could.
Also, during the winter, my name is Nazifa.
Okay, we'll shift
Hold on.
into the.
Or should I come back?
Are there any other questions of staff?
So I'm not, let me just follow up. So was there a building permit for this
Yeah.
change that preceded coming through zoning?
Not for the change, there's a,
They said that you don't need.
Hold on a second, Ms.
Please
Nawaz.
sit
We'll
down.
get to you in just a moment.
So was there, I thought I read there was a building permit. Was there a building permit?
not for the proposed work.
Not for the
Not that I'm
proposed addition? Okay,
aware of.
I'll read this more carefully then. Maybe I
Mr. Rissy.
misread it.
Yes.
Mr. Owen?
Are there any pending enforcement actions on this site?
Not
You're
that I'm
aware
aware
of?
of.
Okay. Was there a building permit issued for the structure, the main structure that currently exists?
Yes.
Okay. The staff report indicates that maximum lot coverage for the main building on this parcel is 40%. Is that right?
That's what's in the staff report, yes.
Okay. And the actual maximum lot coverage of the current condition is greater than 40%?
Correct.
Is that the approved, is that the lot coverage that was approved in the building permit that was issued for the main building?
Yes.
So the building permit may have been issued in error.
That's one possibility. There is another possibility. The issue here really revolves around the size of the front porch. In the documents that we had to review for this application, the porch does not appear to be 60 square feet. And that's just what I'm reviewing for this application. That's what I reviewed when we wrote the advertisement. In the building plans, it was suggested that the porch was over 60 square feet. If that porch is in fact over 60 square feet, then they are allowed 43% lot coverage. But again, there's a discrepancy between what was approved and the plans that have been submitted for this application.
The 40, so then I didn't state it correctly.
Okay.
The maximum lot coverage of 40 is not main building, but total lot coverage.
That is the maximum lot coverage, yes.
Okay. So the total lot coverage is currently permitted to be 40 if the porch is small.
Yes,
And the actual total lot coverage is 40.81.
correct.
But it may be that, in fact, the porch that now exists has been mismeasured, and it is big enough to trigger a total lot coverage of 43%.
That's one possibility, yes.
One possibility. Okay. In terms of main building coverage, and I'm just reviewing what was on the staff report, the main building is 31.9%, and the permitted main building is 30%, again, unless the porch is big enough, in which case it's 33.
Correct.
So the applicant is proposing 46.57%, which would be bigger than any of those, which would definitely exceed any version of the permitted lot coverage
Correct.
for total lot coverage. And the application's not proposing to expand the main building.
Correct.
Okay. The staff report uses the words existing non-conforming to describe the amount of lot coverage used on this site. The term existing non-conforming is a term in the zoning ordinance that is highly defined. Was staff meaning to use the term existing non-conforming in the sense that it is defined in the zoning ordinance?
I would have to review the definition of existing nonconforming
Typically, existing non-conforming describes a thing
that was
was lawful at the time it was constructed, and then the law changed, and now it would no longer be lawful if newly constructed?
I'm not sure that this would qualify for that, but again, the plans that were reviewed were, I do think, lawfully approved. What was shown to the plan reviewers at the time the building was permitted was a porch that was shown to be, according to the plans then, more than 60 square feet. So I don't think that anything was...
Now, I've moved on to a different question, which is whether the existing structure as built, as opposed to as approved,
Well, that's the thing.
existing non-conforming, which are the words used in the staff report.
I'm not sure whether there is an error in the way the building was built or the way that it was measured. And I think that would be the kind of detail that your question hinges on.
Well, one possibility is that it conforms,
Yes.
in which case it's not non-conforming in any sense. Another possibility is that what is there doesn't conform. But non-conformity has a colloquial meaning it's not in accordance with the zoning ordinance, right? But it also has a very stylized meaning within the zoning ordinance. And it sounds to me like the answer is no. Staff did not mean to suggest that this was meeting the definition of existing non-conforming, which actually is a state law also defines that, uses that same term, existing non-conforming, to mean something that's basically grandfathered because it was lawful at one time and then the law changed. This is not grandfathered. There's other things it may be, but grandfathered is not on the list. Is that right?
It is not. I can't say for certain that it isn't grandfathered. What was built is there, and there's no enforcement or reason for us to try and take away anything that's existing currently. I do think that it could be considered legally non-conforming if the situation is that the structure is in fact conforming, but the documents that that have been submitted to us for this application are wrong from the surveyor.
Okay. Thank you.
The order of questions, Ms. Freshman has a question, and then Ms. Malice, and then the chair has a question.
Okay, so the whole coverage thing is confusing to say the least, and it sounds to me like that's a reason to revisit on its face. When I looked at this property and I looked at the left garage bay, I could understand why, as the driveway is currently configured, it's difficult to get in there, but it also has really badly done grading so that if you had a golf cart, you could get in there, but a car, no. And when I was there are pavers in front of the porch, and there was a car parked there. And it strikes me that even if you corrected the grade, you'd be much better off widening the driveway and getting rid of the parking space in front of the porch, which would have the advantage of looking a lot better too. But if the whole problem that we're supposed to be addressing is access to the garage, to the left side of the garage, I don't understand why you just can't reconfigure the driveway in a way that would be much more practical and I think look better instead of jerry-rigging it by adding a few miscellaneous pavers around the edges. Maybe that's more of a statement than a question.
Thank you, Ms.
I
Freshman.
yield.
Thank you, Ms. Freshman. Ms. Malice.
So back to the discussion with Mr. Owen, and I think the chair will follow up too. Why are we dealing with hypotheticals when we could actually know what's going on? I mean, regarding the porch, the size of the porch. Were the drawing, is the porch, how big is the porch? Do we know how big it really is today if we go out there and measure it?
So I have a survey from a signed, sealed survey, and that is what I have to go by today.
So we believe that's the size of the porch. So that porch is less than 60 square feet, or?
According to the documents that I have to review.
And so we're accepting that as a finding, that that's a fact that we're going to base our decision on.
Yes.
Okay.
And thank you, Ms. Mellis. That was, I'm looking at two surveys that are actually in the file. One is dated August 29, 2016, Innova Engineering Consultants, and the other is Huge Surveys dated February 5. I'm sorry, the final survey was October 28th, 2018. And it appears that the 2018 survey from Huge Surveys shows the porch size as 13.9 by 4. Is that correct?
Correct.
And then the Innova Engineering Consultants shows the porch size as 14.32 by 4.
Correct.
If the earlier survey is to be believed, it's still just slightly more than 57 square feet. So that's my calculation. So I don't think if those are the dimensions, they get the additional 3%. Now, thank you, Mr. Rissy, for interjecting.
I will say,
Please.
if that's a question, I will say that the thing that we don't have is the rest of the building permit plans as a part of this.
Right.
I can't say for certain there isn't a floor plan that does show 60.01 square feet for that front porch. But I do agree that both of the surveys that we have here calculate that porch to be just under 60
But we
square
just
feet.
went around this and decided that we have to go by what's in the application.
I do believe that we do. I'm just saying that the plan reviewer who approved the building may have had different material.
Now, I think we're done with questions of Mr. Rissy going through the document. Thank you for your patience, Ms. Sawaz. You've heard that discussion. It was kind of a technical discussion with
That's
respect
right.
to documents that we have in front of us that don't appear to be consistent nor helpful to you, actually. But please, if you'd like to make some comments, we'd be happy to
Sure.
entertain
Thank you so
them.
much for your time. I just want to mention that when the architect designed and drew this driveway and patio, we didn't know that the driveway is small until we got the occupancy permit last December and moved in. If we would have known that from the beginning, we would have made our patio smaller and made the driveway usable. So the house is, as you see, it is kind of elevated, and the left garage is useless. We cannot use it because you have to make a turn to get into it. Even the front is kind of elevated, and in the icy weather and winter snow, if you go slow or brake, you cannot go to the garage. We couldn't use it during the snow time and icy weather. I had to back, and if you go slow, if you stop, the car go back. And we couldn't, and on the right side, there is not enough paver. It easily destroyed the grass. Easily when we back up. We had another house in Arlington that they had enough paver on each side that you can back up your car. Here you cannot. And if we would have known this from the beginning, we would have made the adjustment in the backyard, the patio backyard. And we talked with the Department of Environmental and the neighbors. They don't have any objection. And also they said you don't need a new permit. You can do it with the existing permit that we have. If you allow us to add the paver, only 2 feet we are asking on both sides.
Questions for the applicant?
Have you seen?
Ms. Mellis? Go ahead, please.
Have you seen the staff report? That
I did.
Staff is not, is denying your application.
I saw that. I saw that. Yeah.
Because the standard for a variance is very, very high. We deal with use permits and variances, and the variance standard is the highest one. And that really has to do with whether or not this damages the economic value of your home. It's not whether it's convenient or inconvenient or whether the engineer made a mistake, but the variance standard, the law that we have to use is very high.
Like I damaged my car, like just trying during the icy or try to get into the, I don't know. But I just thought that we spent so much money in this house and this garage, both garages kind of useless. The driveway, backing up, it's just, I wish we knew that. We didn't know that. It's not our fault, the engineer who designed this. We looked at the drawing, we didn't know anything about it. We wish we knew about it. We could have made the patio smaller. We didn't need that much big of a patio in the back. It's all permeable, but yeah, we want add the paver, non-permeable.
If I might, have you discussed with your builder modifications that might bring your coverage down, like reduction in the size of the patio in the back?
We didn't know that until everything was built and we moved in. We didn't know.
I mean, since you've learned of this problem. So I'm hinting at whether it would be beneficial for us to give you more time to not make a decision tonight, but give you more time to talk to your builder about possibly
My
modifying.
builder, he's out of business.
Okay, a builder for the purpose of making changes that might bring your lot coverage down to make it maybe a little easier, because that, if you're
How can we do it?
If your porch size is it's undetermined right now. We don't really know, based on what's in front of us, what the actual size of your porch is. A matter of a few inches in either direction could give you a little bit more coverage. Could get you up to 43%. And then going from 43 to 46 might be a little easier by shaving here or there, or bringing your coverage down and making it possible to have a by right increase in the size of your driveway.
As you know, it is a permeable. They had to dig a lot of the ground to make this patio and the driveway. And I'm not sure if we have to destroy some part of the back. I'm also an electrical engineer. I'm not seeing something that we can.
So you're a problem solver.
No, I'm not. But I can visualize. I can visualize how can I make the lot coverage smaller. But I'm just thinking that I'm just thinking right now, how can we make this possible?
Ms. Malice?
Well, I believe that Ms. Freshman had an idea on how you could reconfigure to increase the width of your driveway by reducing the size of the pad in front of your porch.
There are a number of ways. You've alluded also to the patio in the rear. Ms. Freshman?
Hearing all the conversation, it seems to me that I would certainly support the staff recommendation, but I would also support a deferral so that the applicant can answer the question of the size of the porch in a way that defines what coverage we actually are talking about as a baseline, and then looking at ways if you can get from 40 to 46 or 46 to 40 or whatever. I don't think we can do that now. And that would be preferable to a denial during which time on a deferral you could get some professional advice about how to make this work.
And to follow up, staff could also help you with respect to understanding what our dilemma is with respect to your application. If you were accorded more time. We don't meet in August, So the earliest would be September, and that might afford you enough time to answer some of these questions. And
I would go longer.
and maybe longer is advisable, maybe October even. But you're currently in a status where, from starting with Mr. Owen's first discussion, you're in violation right now, whether that was by error of the planner who approved the plans initially, or by a builder error, we don't know. But the coverage is at a little less than a percentage over right now, but it's over. And that's an existing I don't want to call it non-conforming either. That's an existing problem. So a remedy, I think, is in order regardless. Some work has to be done. Some shaving has to be done. Unlike the case that we had many years ago where actual siding had to be taken off and someone had to take a big saw and cut part of the, say, roof off. You're not in that condition. You're in a much smaller problem, but there still exists a problem if we did nothing at all. So giving you more than what the law allows right now is problematic from a couple of points of view. I'd encourage you to consider the opportunity to defer this matter from tonight to a couple of months down the road to gain some additional information that might make it easier for us and yourself, and cheaper, actually, down the road, possibly.
It would also have the advantage of getting some demonstration of neighborhood outreach and support, which we don't have.
That's the other thing. Thank you for bringing that up. Talking to all the neighbors, both in front, on each side, behind, is kind of critical. I think it says that in terms of outreach, there is
None.
none.
So if I can get a letter from them, would that help?
No.
Mr.
Well, yeah,
Chairman,
you're going to have to talk to them
Mr. Chairman,
regardless. Mr. Owen?
so I'm not convinced that a deferral is helpful because the state law forbids us from granting a variance when the hardship was created by the applicant.
Certainly.
So we have brand new construction, and what's creating any version of the hardship created, which is that the lot coverage is unreasonable the lot coverage requirement is unreasonable, right? That's the hardship alleged, is generated by a house and associated structures that are at or near the very maximum, that are freshly built.
At the maximum or over the maximum.
So I think we would be prohibited from approving a variance at any time. And I'm a little bit reluctant to suggest that this applicant run around and talk to neighbors and do the other thing when, in fact, that she's going to have to work within by right options. Now, we happen to believe, I think several of us, that there are some readily available by right options, and that with consultation with a qualified architect, in not very much time, they could provide you with maybe even more than one option that you could consider that, would involve probably doing things like taking up bricks from someplace to put them down someplace else. It might involve expanding the porch, but a professional architect with training in these zoning ordinances very likely can provide you something that doesn't even require you to ask our permission. And then on top of it, I don't see a version of this that allows us to ever say yes. And so I wonder about dragging out the staff time and at a future meeting having other people wait in line and all that stuff. Like, why don't we send the applicant on the correct path to begin with, which is to find a by right option?
Mr. Chair?
Thank you, Mr. Owen. Mr. Milne?
I wholeheartedly agree with Mr. Owen on this. I was thinking about how to, state exactly what I was thinking, and you stated exactly what I was thinking. But, the standards here, there's, first of all, what we're looking at, this is not an unreasonable restriction. The variance, the rules, and plus it's not a hardship. And, and plus it would be a terrible precedent, for someone to build a property, max out the coverage, and then want more improvements to something, to widen the driveway or this, that, and the other. It would just, then, who's to stop anybody from maxing out the house, and then the driveway is just too narrow, so you make it wider, because you're running off the side of it. So I can't imagine any improvements to this, any widening where I would agree that the standard for variances are met. So, and you do seem very sincere, in your efforts here and how you're trying to solve the problem. But I think the best thing we could do, as strange as it seems, is provide a denial and then just, let you know that you really do need to just adjust things, for the coverage. Just adjust them, but like you say, it's just a waste of everyone's time and, for you to make all these efforts. If, I know I can't vote for it. Doesn't sound like Mr. Owen can. I don't know about the others, but I think that's just a better use of your time and everyone's.
But if I do, I will hire an architect to figure this out for us. But if we need just a few feet to make it, workable for us, you still would not consider our application?
Well, the problem that Mr. Owen, I think appropriately described, is that
By law.
this is not a, doesn't have to do with the topography of the land. It has to do really with your own construction. It was built too big. That's where it starts. It wasn't, and there isn't a hardship that you came into. You created the hardship. I was offering an opportunity to have you assess that with a professional and try to get within the law, because I can't disagree with Mr. Owen or Mr. Melnick at all, that it is a problem that was created by, not by you personally, but by the construction, by your construction, as opposed to the land being either steep or the lot being narrow, or it being something unusual with respect to the land. After hearing, I find myself also I'd be unable to support any kind of granting of variance. Lot coverage is one area. It's not like side yard setbacks. We can use the use permit for side yard setbacks, and the burden is not as high. But with variances, the burden is much higher, and we have much less wiggle room to fashion a decision.
Mr. Chairman,
Mr. Owen.
I move that the Board of Zoning Appeals adopt the attached proposed resolution denying variance V-11474-19-VA-1.
Second.
I'd like to, Mr. Chairman.
Thank you, Mr. Owen, and I'll take the second from Ms. Malice to my right.
Mr. Chairman.
Mr. Owen.
I'd like to offer an amendment by unanimous consent to add a new third whereas clause. Whereas the BZA finds that the terms of the zoning ordinance do not unreasonably restrict the utilization of the property. And
That's the resolution in addition. Is there unanimous consent
No objection.
to adopt the amendment to the resolution? It's so moved. Any further discussion of the motion as amended? Hearing none, all in favor of the motion which denies the variance application signify by saying aye.
Aye.
Aye. All opposed? Unfortunately, Ms. Sawaz, the ayes have it, and your request for a variance is denied. Mr. Rissy, please call the next case.
Case number V-114 475-19-UP-1 is a use permit request by Kevin Lilly and Thu Ten Nugent. The owners to permit a left side setback of 7 feet to the building wall from the side lot line instead of 10 feet to the wall as required, and to permit an aggregate side yard of 16.8 feet instead of 18 feet as required regarding a proposed two-story side addition in the R6 zoning district from what's known as 412 North Norwood Street. Staff recommends that the board adopt a proposed resolution granting the use permit request with conditions.
Thank you very much. Any questions of Mr. Rissy? Hearing none. Let me say for the audience's benefit, the first two cases that we had were very difficult cases tonight. I don't want you to be dissuaded from vigorously pursuing your cases. They involve difficult questions that we get these reports in advance and analyze them and have an opportunity to analyze them. And so I think much of what you'll hear for the remainder of the night is far less.
Yeah, for the rest of you will have it easier.
We're a little worried.
Let's hope. And so the next applicants are Kevin B. Lilly and Thuy Nguyen Nguyen. Would you like to make a statement? Anything to add to the report?
I'm glad to be the first easy one. I'm Kevin Lilly. I've been a resident of Arlington since I was born. I've been here before for other homes, so I kind of know how it works. So I did kind of realize those were out of the ordinary. Thank you for your time. I don't really have any comments. I think it's fairly straightforward if you have any questions of me.
Thank you very much. Any questions of Mr. Lilly? Okay, well, the matter's with the board.
Mr. Chairman,
Ms. Malice,
I'd like to make a motion.
I'd be happy to accept it.
As soon as I find it. Got it. I move that the Board of Zoning Appeals approve the attached proposed resolution approving the use permit V-11475-19-UP-1, subject to the conditions listed in the staff report.
There's a second. Thank you. It's been moved by Ms. Malice, seconded by Ms. Freshman, that we adopt the attached report approving the subject use permit. Any additional comments?
Mr. Chairman,
Mr. Owen.
I would like to offer an amendment by unanimous consent that the last whereas clause be amended. The purpose of my amendment is that the last whereas clause, which by the way is the same text for all the remaining items in our packet. So this is
July 20.
So let's
hear it.
just finish my sentence. So the last whereas clause in all of these use permits says that we're comparing to structures in the county, but that's not the legal standard. The legal standard is surrounding the lot in question. So in the last whereas clause, which is at the top of page 5, near the end of the second line, let's see. The second line's
The middle of the third line, really.
Yeah, so instead of in the county, it should say surrounding the lot in question.
To comparable structures surrounding the lot in question.
To comparable structures on other properties surrounding the lot in question.
Got it.
And then following.
And the proposal would help preserve the
Okay.
natural landform, et cetera.
So in the county is replaced with surrounding the lot. Repeat that, surrounding
Surrounding the lot in question,
the lot in question.
which is the text of the zoning ordinance.
Mr. Chair,
Thank you, Mr. Melnick.
so that's, just so I can be sure, so it's properties in the county surrounding the lot?
No, eliminate in the county. And replace those three words with the four surrounding the lot, the 5 in question.
Placement similar for comparable structure.
On other properties surrounding the lot in question. And the proposal would help preserve.
So that's my unanimous consent request.
No objection? No objection.
No objections. It's so moved. Any further discussion? Hearing none, all in favor of granting the subject use permit with the amendment to the last whereas as discussed, signify by saying aye.
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 All opposed? The ayes have it. The matter is granted. Thank you, Mr. Lilly. Please call the next case.
is case number V-11476-19-UP-1. It's a use permit request by 1247 North Stewart Street LLC. The owners permit a right-of-way setback of 15 feet to the building wall and 16 feet to the porch, 13.3 feet to the building eave, 14.1 feet to the porch eave from the 13th Street North right-of-way instead of 25 feet to the wall, to the building wall, 21 feet to the porch, 21 feet to the building eaves, 19.5 feet to the porch eaves as required, and to permit a rear setback of 2 feet to the garage, 1 foot to the garage eve instead of 10 feet to the garage eve as required from the rear property line. Regarding a proposed new 2.5-story one-family dwelling in the R5 zoning district, premise known as 1247 North Stewart Street. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions.
Questions of Mr. Rissy? Hearing none. The representative of North Stewart Street LLC is, I don't have a speaker slip in front of me, so.
We are the owners.
You are the owners. Who are you?
My name is Terrence Mendes and my wife Bridget.
Can you, at the conclusion of your remarks, fill out a speaker slip?
Yes.
Absolutely.
Okay. Anything to add?
No, we would just like to offer our time for any questions.
Yeah, we've had great support from the neighbors and the neighborhood. Reviewed our plans with most of the neighbors that we could get a hold of, and they have been very welcoming and excited to have us. So we're looking forward to getting an approval.
Mr. Chairman?
Thank you. Ms. Mellis?
Could I, do you have a copy of the report in front of you?
I believe there's one there.
There were a couple of neighbors that I didn't see responses from.
Yes, we had, there's a neighbor directly across the street in the yellow house that's similar.
Yep.
And there is a neighbor that's directly, if you're standing in front of the house to the left.
Right.
We made several attempts to reach out to them, knock on their door. We left a copy of the letter and the plans taped to both doors. We also did that with the house that's directly behind that faces 13th. That homeowner did respond to us, called us with a couple of questions, and did mail the letter back to us. The other two we never were able to reach or get a response from.
Okay. Thank you.
Additional questions of the applicant? Ms. Freshman?
I'll just ask my perennial question of people who are tearing down a house and building new. What about this property constrains you from staying within the boundaries for by right construction? So that, because typically when I look at new construction, I say you have all the flexibility in the world.
I would say that the number one reason is because it's a corner lot, and if we use the current footprint that's there and we extend it beyond where it is right now, it's only a two-bedroom, one bath. So to give us a reasonable size home, we would have to go beyond the current footprint, which would then reduce the width of the house to 17 feet or less. And so it would be difficult to construct, and it would not look attractive. And what we're trying to propose is, of course, keeping on the same footprint, but just extending it further. So we're not asking for anything additional to the right-of-way. We're really only asking to allow us to add a little bit more in depth so we can make it look more conforming to what's across the street and what has also been being built in the neighborhoods.
We're also a family of 6, so we can't really live in a 2-bedroom, 1-bath house.
Any additional questions?
Can I ask?
Ms. Mellis?
In a similar vein, you're requesting a relief from the rear setback for the garage?
For the garage, yes.
Is there a reason that garage couldn't be placed elsewhere?
Well, there's a driveway entrance from the street that's directly in front of.
So you're basing it off an existing curb cut?
Correct.
Right.
Which is almost the very edge of the property, and in that case, if we had to move it over any further, we would actually have to zigzag through the property. We're trying to just really make it simple and.
Well, you wouldn't have to. You could just move the driveway, right?
Yes, of course.
We could move the driveway, but that would also eliminate our yard space for our children in the rear.
Additional questions? Comments? much.
Thank you.
Thank you.
And if you complete that speaker slip. Only because you're an LLC and you're a juridical person and not a real live human being in this case as an applicant.
You can
Matters with the board?
ask
Be happy to accept any motion. Mr. Melnick?
Mr. Chair.
questions.
Oh,
Quest-
sorry.
Yeah,
There
one
is
more
an additional
for
question.
the
Mr. Melnick?
Yeah. So, just to confirm, so you're, doing this construction, and then you're going to live in the house, you're going to occupy it?
We're going to occupy it.
Because I noticed that the LLC was the applicant. It sort of appear like a builder.
We bought it as in an LLC because it's not buildable for us. So if we didn't get the special use permit, we will have to renovate it, the existing structure, and then just resell it.
Okay. Yeah, that was my question, because I noticed your letter was just from you, but it didn't mention the LLC, and that brought it to my attention. Whether you are a builder or you aren't, or and also, just for the staff, it looked like you were listed as owner, like on the disclosure in the application, but it didn't. It didn't give you representative capacity of the LLC, like member or manager. And maybe that could be clarified.
Yeah, we approached Mr. Risi several times on that subject, and we tried to provide notarized documentation that we were who we were. We were fully prepared to obviously show identification if we needed to, and we were under advisement from Mr. Risi and his staff.
We are the only two members of the LLC.
Member managers?
Yes.
Okay.
And is the title owner of the LLC right now?
I'm sorry?
The acquiring, whoever acquired the property on the deed, is that the LLC? Like, you personally don't have an ownership interest?
No, we both personally have an ownership interest. When we bought the property, we bought it as managing members of the LLC, and we personally signed and personally guaranteed the note on the property. So it's recorded in the county as the LLC and both of our names.
Oh. So it's not just the LLC that owns the property right now, like the grantee on the deed, it's you two personally and the LLC?
Well, we personally guaranteed the note, so it's recorded as us personally guaranteeing the note on the property, the loan on the property, and the LLC is the owner, and we're the managing members personally guaranteeing the note. That's how it's recorded.
I gotcha. Okay.
Thank you very much for those clarifying questions, Mr. Melnick. I'd be happy to entertain a motion if there are no further questions.
Mr. Chair?
Mr. Melnick?
So I'd like to move that the Board of Zoning Appeals approve the resolution granting the use permit in case B 1147619 UP1.
Is there a second?
I'll second. I assume it's going to be amended.
Mr. Chairman,
Thank you very much. It's been moved by Mr. Melnick, seconded by Ms. Freshman. The chair recognizes Mr. Owen.
I ask unanimous consent to amend the final whereas clause in the same manner as on the previous item.
Without objection, that amendment is made, replacing those three words with the five surrounding lots.
In the
versus-
county, being replaced with surrounding the lot in question.
I'm fine with that.
Thank you very much. It's been approved by unanimous consent. Any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
All opposed? The ayes have it. The matter is granted. Congratulations.
Thank you so much.
Appreciate it.
And Mr. Risi, please call the next case.
Case number V-11477-19-UP-1 is a use permit request by Andrew Krug, the owner, to permit a right side setback of 5.7 feet to the wall and areaway, 4.3 feet to the eave from the right side lot line instead of 10 feet to the wall, 6 feet to the eave and areaway as required, and to permit an aggregate side yard of 14.3 feet instead of 18 feet as required regarding the proposed one-story rear addition over basement in an existing one-family dwelling in the R6 zoning district, premise known as 5605 4th Street South. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions.
Any questions of Mr. Risi? Hearing none. Be happy to hear from the applicant, Andrew you have anything to add?
Actually, Kelly
Welcome.
Krug, his
Hey,
wife.
hey, this is the owner, Mrs. Krug. I'm the builder.
Okay.
Van Vano. Sorry about that.
Mr. Krug, would you please, at the conclusion of your remarks, fill out a speaker slip?
Yes.
You're not Mr. Krug.
Mr.
No,
Krug.
sir.
You're,
I'm the builder. I'm just
And your
helping
name?
them. Tim Van Vano,
Oh, you're
and the
not Mr.
company?
VP Construction.
Okay. And you are Ms. Krug?
Yes.
Thank you very much. So you're going to have your builder speak for you?
I'm happy to speak. Thank you
Okay.
for having us and considering this. I just wanted to let you know that we have 2 additional letters from neighbors that we were able to obtain after the application, if you would like those.
That would
of
be very
support.
helpful. Thank you.
Just give us the address.
The address is 300 South Jefferson Street and 5608 3rd Street South. They're the houses kind
Excellent.
of to our back diagonal.
Home run.
Thank you very much. And Ms. Krug, also, would you fill out a speaker slip too? Because I'm noting on the disclosure statement and on the application that it's, that it speaks only in the singular of Andrew Krug, and he has signed everything. So having in the record a document that identifies.
Yeah, I
you-
apologize. He had to go out of the country for work, so we
That's
just
fine.
had to do a little.
That's-
But you are an owner?
I am the owner too, yes.
Okay.
Because there's a series of applications and disclosures, and your name doesn't appear on any of them.
So if you would just fill out a
Sure.
speaker slip and indicate on that speaker that you're the wife, and maybe,
That's a
maybe it
domestic
was
issue.
he overlooked the fact that that was kind of required in the disclosure in general. The disclosure would list.
Okay.
Like in the prior case, both of those individuals were listed as 50% owners of that
Okay.
LLC. And generally, it's a husband and wife. There is some indication of that. We don't have anything.
Okay, I
on record
apologize for that.
indicates That's all.
That's a domestic oops moment.
Yeah.
We can fix that with speaker slips.
Okay.
But that doesn't, I haven't heard any substantive questions, really.
He's going to ask.
Okay, Mr. Melnick.
Oh, I'm good.
Yeah,
have a question?
I was just gonna,
Point that out?
yeah, and
Okay.
just,
To be the disclosure statement probably should be updated.
Yeah.
Okay. We'll make sure all of that gets updated. Thank you.
Well, it may or may not be. He may be listed as on the deed as the sole owner. We don't really know.
At closing, were you sitting next to him initialing everything he was initialing?
We're both. I'll make sure the changes are made. We're both on the deed and
Okay.
we're both there on the owners.
So why we ask about it is we don't want to get into a situation where a third party comes to us making changes on property that they don't own.
Right. Okay. I understand that.
And agents, they have to sign, the owner would sign a note authorizing an agent to speak for them with respect to real property.
Okay.
Ms. Freshman?
I appreciate your letting us know about the additional neighbor support. I would have to congratulate you on hitting a home run when it comes to getting your feedback, which we don't always have. And I'm prepared to make a motion.
Any other questions of the applicant or her builder? I'd be happy to entertain a motion.
Yes?
Ms. Freshman?
I move the Board of Zoning Appeals approve the attached proposed resolution approving the use permit V-11477-19-UP1, subject to the conditions listed, with the anticipated amendment.
Mr. Chairman, I second the motion.
Thank you very
I
much.
ask
The move by
unanimous-
Ms. Freshman and seconded by Mr. Owen. Mr. Owen has the floor.
Mr. Chairman, I ask unanimous consent to make the same amendment that we have done on the last two motions.
No objection.
And there is no objection. Duly noted. Any further discussion? Hearing none, all in favor of the motion to grant the subject use permit in this case signify by saying aye.
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 All opposed? The ayes have it. This matter is granted. Thank you very much. Thank you both for coming.
Thank you.
Please call the next case.
Case number V-1147A-19-UP-1 is a use permit request by Alexander Dennis and Carrie Dennis, the owners, to permit a right-of-way setback of 22 feet to the building wall, 20 feet to the eave, 19.8 feet to the porch, 17.4 feet to the porch eave, and 18 feet to the window well from the 26th Road North right-of-way, instead of 25 feet to the building wall, 21 feet to the eave, 21 feet to the porch and window well, 19.5 feet to the porch eave as required from the right-of-way, and permit a rear setback of 23.8 feet to the rear bump out instead of 25 feet as required from the rear property line, regarding a proposed new two-story single-family dwelling over basement in the R6 zoning district, premise known as 5310 26th Road North. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you very much. Questions of Mr. Rissy? Hearing none. Alexander Dennis and/or Carrie Dennis. Mr. Dennis, welcome. Anything to add?
Thank you. No, I just wanted to thank you for your time tonight, and to Mr. Rissy and the staff for your time. I just want to say my wife and I, my name is Alex Dennis, and I'm here with my architect, Rob Schindler, who's been tremendously helpful to us in this process. We've lived on 26th Road since 2011. Our children are in the elementary schools there, and we wanted to keep them there, but we wanted to have more space. So last November, we bought a property 2 blocks up the hill from where we currently are. And we're evaluating whether to renovate or build, but there were significant plumbing and foundational issues, and we decided to build. We're cognizant of the surrounding 1940 homes on the cul-de-sac, and in keeping with the not-too-big feel of the cul-de-sac, our plans have no garage. We have no third story. Total square footage that's lower than many new builds in the county, and a craftsman style that's consistent with the other houses. The lot is 5,248 square feet, which is 752 feet smaller than a normal 6,000 square foot lot in R6. The main driver of asking for the use permit is we're trying to put a front bedroom in, main floor bedroom for my in-laws who are often in town, and wanted to make that about 12 and a half feet wide instead of 9'7" as it would have been. We have letters of support from all 8 adjoining neighbors, and our intent was to ask for a modest change in the setback requirements. And I'm happy to answer any questions.
Thank you very much. I will note that I like the way that you identified the surrounding neighbors, categorized them, and listed them on a separate sheet.
Very helpful.
It is helpful. Ms. Freshman.
It's actually a question for staff, but in the staff report on page 2 where it says the application proposes to increase the total lot coverage to 39.54%. And what's the max? I don't have one of those charts here that tells me what the max is. I guess the reason I'm raising it is because you heard a previous application. And if you're not really happy with how the driveway works or the size of the patio or any of that other stuff, if you're maxed out on your coverage now and you have the choice because you're building, just being aware of those issues is really critical so you don't ever have to come back and, you know.
Sure, understood.
Mr. Rissy, would it be the same table that's on the previous item, 11474, that we previously considered?
It would. It is.
Okay.
So reading from that table, it appears that this structure does have the qualifying 60 square foot front porch. So the total lot coverage in the R6 zoning district would be 43%.
Okay. So you have a little wiggle room. Yeah. Not a whole lot, but given that you're starting from scratch, that's always something to keep in mind.
I will note that Mr. Schindler, the architect who is present, was nodding with a clear sense of understanding of that.
Okay.
Any further questions or?
Mr. Chairman,
Rowan?
I would just say that the applicant's diligence in obtaining neighbor feedback, the modest, less than maxing out that we see here, like sometimes during our organizational meetings, we think, should there be a sample application that we show people?
We could keep this one.
This would be one to note as a potential sample application.
Yeah, for a new build.
Yep.
I mean, as you saw at the previous case, Ms. Sowas's case, I mean, we see it over and over and over, building right up to the edge. I mean, within fractions of a percentage, and that's really buying yourself a problem. Anyway, anything,
Mr. Chairman,
Mr. Owen?
I'd like to make a motion.
I'd like to hear it.
Mr. Chairman, I move that the Board of Zoning Appeals approve the attached proposed resolution approving use permit V-11478-19-UP-1, subject to the conditions listed and with the modification to the final whereas clause that we made to the previous 2 or 3 applications.
Second.
Thank you very much. Moved by Mr. Owen, seconded by Ms. Malice to approve the subject use permit. Any further discussion with the modification in the last whereas? Hearing no further discussion, all in favor signify by saying aye.
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 All opposed? The ayes have it, the matter is granted. Thank you very much.
Thank you.
Mr. Rissy, please call the next case.
Case number V-11479-19-UP-1 is a use permit request by Thor Young and Erica Freud. The owners to permit a right-of-way setback of 10 feet to the building wall, 9 feet to the eave of the addition, instead of 25 feet to the building wall, 21 feet to the eave, as required from the easement for street purposes adjacent to the First Road South right-of-way regarding a proposed 2-story rear addition in the R6 zoning district, premise known as 113 South Utah Street. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions. And please note there is supplemental material for this case that came in after the application packet was assembled and printed. And it is an email from the applicant stating that she will be unable to attend the hearing and that her builder will be representing her.
Thank you very much.
Mr. Chairman,
I'm looking at that. Mr. Owen,
I have a question for staff.
let's hear it.
What is the width of the portion of the right-of-way on First Road South that abuts the applicant's property? In other words, how wide is the street in that location?
According to DES records, the 1950 subdivision plat shows a 25-foot right-of-way dedicated in fee with a 5-foot wide easement for public street purposes along the property frontage. The combination of the two is a 30-foot wide street.
Oh, I'm sorry. Can you repeat the last 2 sentences there?
5 plus 30.
I think that's one sentence. According to DES records, the 1950 subdivision plat shows a 25-foot wide right-of-way dedicated in fee with a 5-foot wide easement for street purposes along the property frontage. The combination of the two is a 30-foot wide street.
Okay, got it. Yep, it looked smaller than 30 feet, but it actually is 30 feet.
Well, with the 5-yard easement, it's 25 plus 5.
And that's significant because the definition of street in Arlington is a 30-foot right-of-way.
Yep.
And if it's not 30 feet, it's not a street, and if it's not a street, we don't need to be here.
Yes.
We do, for other people.
I have other cases.
I mean, was there a need for an application for a use permit, really is the underlying question.
Yep, okay, but it turns out it is 30 feet, so we do need to be here, so ready to proceed.
Thank you very much, Tom. And we don't have to ask Ms. Floyd to make any remarks. However, she indicates that her
Humberto.
the contractor will be present. Welcome. You, if you would just fill out a speaker slip to indicate your presence, to give validity to the statement by Ms. Floyd, I'm sure she would appreciate that. You don't have. You can do that after if we have any questions or if you need to make any remarks. Do you need to make any remarks?
No.
Okay. Thank you very much, Mr. Owen.
I move that the Board of Zoning Appeals approve the attached proposed resolution approving use permit V-11479-19-UP-1, subject to the conditions listed and with the modification to the final whereas clause identical to the ones on the previous applications.
Thank you very much. Moved by Mr. Owen. seconded by Ms. Malice, and with the usual modification of the last whereas, which we will adopt by unanimous consent. Any further discussion? Hearing none, all in favor of the proposal signify by saying aye.
Aye.
Aye. All opposed? The ayes have it, the matter is granted. Thank you for being present also. And Mr. Rissy, if you would call the next case.
Case number V-11480-19-UP-1 is a use permit request by Susan Tyler and Patrick Johnson. The owners permit a right-of-way setback of 14.8 feet to the building wall, 14.6 feet to the eave, instead of 25 feet to the wall, 21 feet to the eave, as required from the 21st Street right-of-way, and to permit a separation of 7.9 feet from the wall of the addition to the wall of the detached garage instead of 28 feet as required, and to permit a separation of 3.2 feet from the proposed landing and steps to the wall of the detached garage instead of a minimum of 4 feet as required, regarding a proposed one-story rear addition to the existing building in the R5 zoning district, premise known as 2100 South Joyce Street. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Mr. Chairman,
Thank you. Mr. Owen?
a question for staff.
Yes.
Earlier this year, the BZA requested that the county board clarify the rationales, if any, for the 8-foot interior setback requirement, which I guess I learned this month has a 4-foot setback requirement in the case of landing or steps. Has there been any further clarification in the meantime regarding the rationale for these interior setback requirements?
Not that staff is aware.
Separation, you're speaking of the separation?
The interior 8-foot
Yeah.
separation requirement. So no further clarification at this time is the answer I hear from staff? Is that
Correct.
right? If not, does it seem like one might someday be forthcoming?
I can't answer. I'm not sure what will be coming to staff as far as any advisement from the county board on the rationale.
Okay.
So,
Oh, Ms.
can I
Malice?
just follow up?
Yes, go ahead.
So what is the mechanism for getting that information?
It could be issued to staff as
No, but does the county board know of the request?
they were shared your letter asking for clarification on the matter, though I do have an interesting tidbit of knowledge,
Okay.
if you would like me to share it.
Certainly.
In preparation for one of the other questions that didn't get asked this evening, we did some research to find out when the 8-foot separation was put in place.
It was 15 before.
It was 15
I
before.
remember that.
And it was put in place, I believe it was November 2000. And I can't, of course, speak to the rationale of the board making the decision at that time, but in the staff report, there was noted a reason for, this was part of a larger package of changes to the zoning ordinance, and part of the reason for requesting those changes was to reduce the number of BZA applications. Staff suggested that if the county board accepted all of the recommendations that they put forward, which the county board didn't, that they would reduce the number of BZA applications by 60% the following year.
Oh, my goodness.
I think that's why I remember it.
So, again,
Imagine how few there would be if the requirement was 0 instead of 8 feet.
well, what's interesting is, and there was a lesser setback that was proposed by staff at the time that did not get adopted. So the reduction was not as much as staff anticipated.
Maybe it would be worth checking with the county board clerk or with the director of planning and zoning or someone to see if the board has, or the chairman has referred the question to anyone for further review or study.
Because, I mean, if we wrote as an individual, it would become a gram, and then it would be on a clock, right? So somehow, can we get on a clock?
I guess if I wrote and would that be in the form of an email or?
Yeah, just an email
That would
board office
suffice.
saying, there's a process and a timeline.
Well, let's discuss that after, at the conclusion of this meeting briefly, with respect, because I don't think that's the only question that we have that really the board should answer. I think the question of significant trees, what that phrase means and who's to answer it.
It's in the same letter.
Yeah.
Yep.
So, okay. Any further questions, Mr. Owen?
No. Thank you, Mr.
Thank you very much. Any further questions of the, on this, of staff on this proposal, on this application? If not, Susan Tyler and Dora Patrick Johnson, present. All present and accounted for. Anything to add? That was a discussion that was kind of internal. It didn't have anything to do with
We're
your
glad to
application.
inspire that conversation
Totally
for
did.
you all.
That's the thing they're asking for an exception?
No, I mean what the policy was and how it came about and what the history.
Yeah, it's relevant.
They're the beneficiary.
I mean, they're the beneficiary. It's not. It's tangential to their application.
We don't have a particular interest in the answer to that one. Hello, I'm Susan, and this is Patrick. We've been living in the neighborhood for a few years as renters, and we are now first-time homeowners, and we would like to stay in the area for a while. I mention us being first-time homeowners because I would like to preemptively respond to, I know we're missing some feedback from neighbors, and part of the issue there is just that we didn't especially know what we were doing, and we had a miscommunication with the contractor about, we didn't understand that this was our job until sort of late in the game, and then we've been traveling throughout the summer and didn't totally understand the sort of feedback that we were supposed to get, but now we know for future reference. And also some of the, part of the project relates to heating issues in the home, and so we still wanted to try and move the project along as quickly as possible because our house is very, very cold in the winter, and we would like to get it done before it starts to get too much colder. So we apologize for the lack of a few homes not having feedback.
Thank
Mr.
you.
Chairman?
Mr. Owen.
Do you have any advice for us as to how we, in the Board of Zoning Appeals, or the staff, or the bureaucracy here, could communicate to first-time homeowners such as yourselves about what our expectations are about neighbor feedback? Is there a stage in the process? Is there, like when and how would it have been more helpful to have a clearer understanding of what our expectations were?
I'd just like to comment on your website was very helpful when doing the research for things, and I went through previous reports of like, here are all the things, and looking at what other people had done, and our letter was modeled after another person's letter off of that. I think we may not be the best people to ask about it because of the timeline we were given to, like from when our contractor told us that we needed to be the ones doing this, to when the applications were due to get into this meeting. But I think the offer that was on the table to meet with the staff a week ahead of time to go over your application and everything would have been great if we had been working in that timeline. And so as far as my advice to you all is, I think you're doing a great job, and that's not just because I'd like you to get approval on this thing. I think your website is full of excellent information, and the fact that previous hearings, you can see the applications and model off of those things, I think is very useful.
Go ahead.
Is it clear anywhere in there, and I'm sorry, I haven't looked at that as much as
Yeah.
you have, but just that the other people immediately surrounding our home are like the most crucial people to get feedback from, which is like common sense, but that didn't exactly occur to me. So.
Yeah, I guess that was like the fact that it's the immediately surrounding lots was the crucial part, was not clear to me. It just seemed like we should walk around the neighborhood and talk to as many people as we could, which is what I did, which is why there's a person from like all the way down the block who signed. When I went around the neighborhood, just like knocking on doors, trying to say hi to people, and they happened to be on their porch, and that's how they got included.
So when you were looking for guidance about who we were seeking signatures for, were you going off of what you saw online, or were you going off of what was in some paper materials that you had signed, or that you had been given as part of the application process?
I went to your website and looked at the BZA application, like how-to document, but at the time I was doing most of this research, I wasn't clear on the difference between what a use permit and a variance were, and so I wasn't sure the requirements to go to. When I looked at like examples of these from other applications, it was unclear to me who these houses were relative to the things, because it was just kind of like I saw a list of signatures with addresses, and I could see that they were close, but like sometimes they were split amongst multiple documents, sometimes they that, and there wasn't a clear like. In any of these, I don't think it's necessary to summarize, oh, and these were all the surrounding houses, or we're missing this surrounding house.
Got it.
Like I was trying to extrapolate from what I saw.
Yep, we do. Yeah, as it turns out, we have to do the same thing. So
Yeah.
that's a good observation there. Thank you.
Yeah, you're welcome.
Thank you for your participation in our focus group.
We're happy to help out.
Absolutely. This is a process we've been going through, trying to make it better.
Yeah.
Any further questions of the applicant or staff?
Mr. Chair?
This matters with the board. Mr. Melnick?
I'd like to make a motion.
I'd like to hear it.
Okay, so in case V1148019UP1, I'd move that the Arlington County Board of Zoning Appeals adopt the attached proposed resolution in conditions as stated, granting the use permit request.
Is there a second?
Second.
Thank you. Been moved by Mr. Melnick, seconded by Ms. Freshman.
Mr. Chairman.
Mr. Owen?
I'm asking unanimous consent to replace the words "in the county" with other words as we have done on the previous applications.
Surrounding the property.
No objection.
No objection.
Without objections, that's so moved and so ordered. Any further discussion? Hearing none. All in favor of the motion signify by saying aye.
Aye.
All opposed? The ayes have it. The matter is granted. Thank you very much. Thank you for your feedback, too.
If you want any additional feedback, you know how to get a hold of us. So.
Thanks.
Thank you.
Please, Mr. Rissy, call the next case.
Case number V-11481-19-UP-1 is a use permit request by Timothy Vermel, the owner, to permit a side setback of 9 feet to the building wall from the west side property line instead of 10 feet to the building wall as required regarding a portion of a proposed vertical addition not over the existing walls of the structure in the R6 zoning district, premise known as 4044 Vacation Lane. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions.
Mr. Chairman.
Thank you very much. Mr. Owen?
Question for staff.
Let's hear it.
I understand, as I understand the gist of it, the applicant is prepared to go by right here, but the by right option has a little cutout in it, a little notch or something.
Correct.
And that seems silly to everyone, and so they're asking for a use permit to not have the notch.
Correct.
And staff thinks it's silly, and the applicant thinks it's silly, and the neighbor is going along with it too.
I'm not going to say staff thinks it's silly, but staff thinks that a use permit would be appropriate and has recommended approval.
Okay, thank you.
Thank you very much also, Mr. Owen, for that question. Let's see here. Let's hear from Timothy Fremel. Did I pronounce your last name correctly?
It's Fremel.
Fremel.
Yeah,
welcome. Thanks
Thank
for
you.
coming.
I'm Tim Fremel. I'd like to thank the board and Mr. Rissy for your time. And I like the picture. The roof's already off the house. We're trying to make use of the existing 1953 building rather than scraping and going bigger. And we're trying to create a relatively, we think, modest bedroom home with what we've got existing. And so trying to go vertical and bump out the back enough to create the bedrooms in the back. And yes, the notch is the 3 by 1 foot notch is what's required to go by right. And we obviously already have a permit by right, but we're trying to not have the notch to make the bedroom more usable. And just one unrelated as to the neighbor recommendations. I have recommendations from 2, which are actually because of the geometry of the lot, it's the 3 lot lines because it's the rear and the 2 sides. It wasn't actually apparent to me either that I should be looking for recommendations from folks in front or around. So,
Mr. Owen?
Chairman, yeah. As I understand it, you're asking for something that will occur in the rear of the house,
Correct.
right?
Yeah.
Okay, so having the front neighbors who wouldn't perceive it isn't as important in this particular.
Okay.
We have the reverse problem. Sometimes people don't get the rear neighbor, even though they're doing a rear addition.
Right.
Because they get the people on their street, which is like, well, why would you do that, right? So,
Because of the geometry and the topography here, nobody from the street will ever be able to see this notch.
so mostly what we want is affected neighbors. So sometimes it is appropriate to get even beyond the immediate abutting in a circle around because there's some other neighbor that has a crosswise view or the topography is such. So it's not like a hard and fast rule, but I think it's true that in general, the best practice is all 8 surrounding neighbors in a rectilinear type situation. So you never saw a map or a schematic that showed little X's in the
I don't
neighborhood?
recall seeing that, no.
Okay. All right. We'll talk about that after the end of the meeting. Okay. All right. Thank you.
Just to follow up.
Ms. Malice?
I'm sorry, to follow up on Mr. Owen's point. Sometimes it is useful to go wider, especially if you're doing something that's setting a precedent for the
Yes.
neighborhood.
Yep.
So if you're asking for something that nobody else in the neighborhood has done, that will set a precedent for people 2 blocks away, then sometimes we feel like, well, they ought to have a chance to input into that since, their neighbor might ask for the same thing, the following month.
Like if it'd be the very first carport in the whole neighborhood. As
Noted.
Remember back.
I got that part, yeah.
Yeah. So it's not an exact science. Obviously, the wider you go, the safer you are.
Sure.
But in this case, we understand that you have covered the affected neighbors.
Mr. Chairman.
Mr. Owen?
I'm prepared to make a motion.
Okay, let's hear it.
Mr. Chairman, I move that the Board of Zoning Appeals approve the attached proposed resolution approving the use permit V-11481-19-UP-1, subject to the conditions listed with the modification to the final whereas clause, identical to the modifications we made on the immediate previous applications, to wit, the deletion of the term in the county and replacing it with the 5 words that we've been replacing it with otherwise, surrounding the lot in question.
Thank you very much. Is there a second?
Second.
Thank you. It's been moved by Mr. Owen and seconded by Ms. Freshman to grant the subject use permit in this case. Are there additional comments or questions? Hearing none, all in favor of granting the proposal with the modification in the last whereas as indicated, signify by saying aye.
Aye.
Aye. All opposed? The ayes have it. The matter is granted. Thank you very much.
Thank you.
You won't have to have this odd notch. Please call the next case, Mr. Rissy.
Sorry, before we move on, for the record, I didn't catch who seconded on that.
Ms.
motion.
Freshman.
Thank you.
Thank you. Moved by Mr. Owen, seconded by Ms. Freshman.
And amended.
No, not amended. That was the original motion.
Oh, that's right, you included it, right.
Case number V-11482-19-UP-1 is a use permit request by William Michael Chick Jr. and Jennifer Eileen Chick, the owners, to permit a right-of-way setback of 8.6 feet to the porch, 7.4 feet to the porch eve from the easement for street purposes adjacent to the South Utah Street right-of-way instead of 21 feet to the porch, 19.5 feet to the porch eve as required, regarding a proposed front porch addition in the R6 zoning district premise known as 907 South Utah Street. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you very much. Questions of Mr. Rissy? Seeing and hearing none. William Michael Chick Jr. and/or Jennifer Eileen Chick, and the little one, welcome. Which chick is that?
Good evening. This is, you guys are so good, you put our daughter Billy to sleep. So there you go.
Oh, anytime.
Thank you.
Once a month.
We could change that.
we ran into some childcare issues, so luckily we have good kids. But so I don't think Jen and I have anything else to add unless you have questions for us. The only thing I can say, in addition to the papers that we've already submitted, is that we gave you signatures from all of the neighbors in our cul-de-sac, save one, the one
4406.
immediately on the corner. We did speak with them and we texted with them and they're totally fine with it. And we've spoken to many other neighbors in the neighborhood. The ones that we got signatures for were the ones who were most apparently affected. And nobody has given any opposition. Everybody's been fully supportive of what we've suggested we're going to do. So
if you have any other questions for us, we're happy to answer them.
Thank you very much. Odd-shaped lot, of course. Hearing and seeing no additional questions.
Mr. Chairman?
I'm sorry, I'm going to recognize Mr. Melnick.
Okay, I'm prepared to make a motion.
Let's hear it, Mr. Melnick.
Okay, in case Z11482219UP1, I move that the Arlington County Board of Zoning Appeals adopt the attached proposed resolution granting the use permit request with the conditions as stated, and also with the amendment that has been on previous use permit approvals tonight.
Thank you. It's been moved by Mr. Melnick and seconded by Mr. Owen to grant the subject use permit. Hearing no further discussion, all in favor of granting the subject use permit with the conditions listed and with the modification of the whereas as previously described, signify by saying aye.
Aye.
Aye. All opposed? The ayes have it, and the matter is granted, and the chicks may finally put the littlest chick
Go home
to
to
bed.
roost.
Thank you very much
Meet
for
once
coming.
a month if you need any more.
Oh, yeah, we will happily give you our children to help you
You
out.
can just go to the website and you can listen to the recordings.
They're great at getting
They have the
snacks,
same.
if you need snacks.
Samaletin.
I think my 8-year-old is a little bit too interested in what you are doing.
He's super interested into it.
Oh, the 8-year-old is.
Really?
Oh, both. You have 2 sons back there and a daughter.
We can arrange an internship.
They're in rapt attention. They're recognized. They're being recognized. We see you. Thanks for coming.
Thank y'all very much. God bless
Thank you. Please call let's see, this is the second to last case.
Case number V-11483-19-UB-2 is a use permit request by Frederick Holt, the owner, to permit a left side setback of 6.3 feet to the building wall and porch, 5.8 feet to the building and porch eave, instead of 10 feet to the building wall and porch, 6 feet to the building and porch eaves as required from the side property line, and to permit an aggregate side yard setback of 15.1 feet instead of 18 feet as required regarding a proposed one-story left side addition with side porch in the R6 zoning district, premise known as 378 North Granada Street. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you very much, Mr. Rissy. Any questions of Mr. Rissy? Hearing none, either the Frederick Holt and or Mr. The representative from Cook Brothers.
Thank you. I'm Frederick Holt.
Welcome.
I don't have much to add. I appreciate your effort. I appreciate Mr. Rizzi's effort. I am here with Mr. Tinder, my builder, and I mean, all I would say is we love our Arlington Forest home. We've lived in it for almost 20 years, but those homes were built with a galley-style kitchen that many people have renovated by rotating it to the back of the house, and that's what we're proposing to do here. I know you probably hear this from everyone, but a very modest request with respect to the scope of the setback. And I think it is, the one point I'd like to make is it's very consistent with what's going on in that neighborhood. Several people have made very similar additions. And I would add that that's my dog, that the neighbor that would be the neighbor on that side who would be potentially affected, not only did he sign a letter, but I walked him through it. He checked it out thoroughly.
I must compliment the staff on that photograph. I very much enjoy that.
He's pretty nice. He's safe.
He's peeking out for the picture. Like, who is this? Do I need to attack them or not? I prefer not to, but I'm here if I need to. That's a funny picture. Any questions of the applicant?
I do have one
Ms.
question.
Malice.
And it's partially for staff. According to this, you are the sole applicant, and I noticed that some of your correspondence refers to Allison Holt.
Yeah.
Is she an owner as well?
She is my wife. I believe when we purchased the house, for some convoluted reason I can't recall, she was not present. And so I believe, even though she would very much resent this assertion, that officially I'm the owner of the home.
Okay. Well, in that case, there's no problem with the paperwork.
Okay.
Thank you. Yes, you're right, but She'll get half, don't worry.
Well, I know.
If you didn't bring it into the marriage, it's half hers.
Absolutely.
Generally, that's the case.
Right, I get-
Anything
we gotta
further of the applicant? If not, I'd be happy to take a motion.
Sure.
Ms. Freshman?
I move Board of Zoning Appeals approve the attached proposed resolution approving the use permit V-11483-19-UP2, subject to the conditions listed and with the modification to the final whereas.
Second.
Thank you. It's been moved by Ms. Freshman, seconded by Ms. Malice to grant the subject use permit in this case. Any further discussion? Hearing none, all in favor of the motion signify by saying aye.
Aye.
Aye. All opposed? The ayes have it. The matter is granted. Thank you very much, Mr. Ho, for coming.
Thank you.
Please call the last case, Mr. Rissy.
Case number V-11484-19-UP-1 is a use permit request by James P. Galton Jr. and Jocelyn D. Galton. The owners permit a right-of-way setback of 19.4 feet to the porch, 18.8 feet to the porch eve from the North Oakland Street right-of-way instead of 21 feet to the porch, 19.5 feet to the porch eve as required. Regarding a proposed front porch in the R6 zoning district, premise known as 215 North Oakland Street. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you very much. Questions of Mr. Rissy? Seeing and hearing none, the Gallatons are present. Welcome, Jocelyn and James.
I think it'd be fair for us to say that we know exactly how many years we were before you before, having seen the baby, and that is, we have a 27-year-old son, and the last time we were in front of you, we too brought a baby. And we had come right after a highly controversial and televised appeal to you, which you denied. So I think we were a relief for the entire board when we walked up with a baby and a small request for waiver. So we're back again 27 years later, and we hope you will adopt the staff's recommendation.
Thank you.
And I'll note that the law has changed with respect to air conditioning units also.
Yeah, you wouldn't
We don't have
had-
those.
yes.
We used to have a slew of those.
freezing.
We don't have those anymore because they changed the ordinance to allow for.
That would have been automatic.
Yep. That predates me by about 4 years. I came on the board in about 99, the end of 99. We had a slew of those, and they changed it, along with some other changes that Mr. Rissy described. Any further questions? You didn't bring along the 27-year-old now, though.
He doesn't fit in my arms anymore.
Not as easily. Seeing none, any questions of the Gallatons? Hearing none, I'd be happy to take a motion.
Mr. Chairman,
Ms. Malice.
I move that the Board of Zoning Appeals approve the attached proposed resolution approving use permit V-11484-19-UP-1, subject to the conditions listed in the staff report.
Thank you. Is there a second?
Mr. Chairman.
It's been moved by Ms. Malice, seconded by Ms. Freshman. I'm going to recognize Mr. Owen. I think he has a modification. He's going to ask for
I ask unanimous consent that in the final whereas clause, that the phrase "in the county" be replaced with the phrase "surrounding the lot in question."
Thank you. Is there objection?
No objection.
Hearing none, by
Who
unanimous
seconded
consent,
that?
that last whereas is amended.
Who seconded this?
Ms. Freshman. Any further discussion? Hearing none, all in favor of the motion signify by saying aye.
Aye.
Aye. All opposed? The ayes have it. The matter is granted. Thank you again.
We hope to
for
see you
coming.
in another quarter century.
You won't see me. I have pledged that this is the last term. This is the end of my fourth. I'm approaching the end of my fourth term on this board. So, God willing, you will see some of these other faces, but I hope that you won't have to see mine.
Thank you to the board.
Thank you.
Thank you all for your service.
All right.
Thank you.
Bye-bye.
We have the minutes before us from the previous meeting.
I move approval of the minutes of the June 12th, 2019 BZA meeting.
Is there a second?
Second.
Thank you. It's been moved by Ms. Freshman, seconded by Ms. Malice to approve the minutes as presented. All in favor signify by saying aye.
Aye.
Aye. All opposed? And the ayes have it. The minutes are approved.
It's 9 o'clock?
Let me take a moment to,
Yeah. It's like, wow. That's great.
Anything else for the record?
Mr. Chairman,
Mr. Owen?
I don't want to get ahead of staff, because it's probably to announce two things that they handed to us. But we talked earlier tonight about people being confused about which neighbors they should get sign-off from, and I could have sworn that you guys had started handing out a map.
We have not started handing out the map. We've received the map. We're working on general changes to the application, which we're hoping to roll out sometime during our August recess.
Oh, okay.
While I'm on the subject, I will call the board's attention to another change in procedure that we have implemented this year. I don't know if anyone noticed, but rather than making everyone come in to view the applications, once the applications go out to the newspaper, we are scanning them and putting them online for viewing 1 month ahead of the hearing, essentially.
That's great. We had some residents who came in and requested exactly that, so it's great to see.
So small change, hopefully big impact for the residents.
That's a significant change, though.
Yeah, that's a big difference in terms of transparency.
I want to report on a meeting I had. I was invited to meet with the new director of planning, community planning and development. Is that what it's called?
CPHD.
Community planning.
Mr. Claude Williamson, and it was a very pleasant meeting. He indicated that he was in favor of the Board of Zoning Appeals receiving education, and I indicated to him that it's certainly our desire too. It's been brought up on a number of occasions by members that there are opportunities around, both locally and around the state, for the formal education of BZA members, and that heretofore in the last 20 years I know of, there haven't been opportunities availed of us. We've not been accorded the ability to do that. So his indication that he was in favor of that may foretell good things in the future with respect to that. I think that kind of, and I indicated that kind of training, I think, would benefit all members of the staff and members of the Board of Zoning Appeals to receive that kind of training and education. And so it was a good discussion. I did describe to him some of the challenges that we face with respect to how to treat trees, and who's going to be the person to tell us what significant trees or foliage really are, and some of the other things we indicated, I think, in a letter to the county board. I advised them of that. I also advised them that it's my perception that the staff is working harder than they ever have, both because of I think the more difficult applications that we receive now. They think the easy stuff has been done, and these are more difficult, and the code has changed in many respects to make it to obviate the need for the easy cases, and these are the more difficult cases in general, and that the staff is working very hard there. I have not noted a significant increase in the number of staff, so those who are working harder. And that is difficult for everyone, because the demands, I also indicated to them, the demands that we're making of the staff for information are both hobbled by the directive from the county attorney, but even in light of those limitations, still the demands that we're making are greater than have been in the past. That the staff has tried to rise to the occasion, but it's difficult under many circumstances. And then lastly, I talked about the problems with respect to notice, I wouldn't say, let me not say problem, the unevenness with respect to how applicants are informed about their need to notify their neighbors of their proposed plans. And lastly, I guess the efforts that we've undertaken to create procedures and bylaws with, and that the difficulty it's been for everyone, including staff, in being responsive to that, given the demands on their time. So I was hopeful that as a result of that meeting, we'll be accorded some training, and maybe there'll be some relief on the staff down the road with other changes that could be made. So that's one indication. That's one outreach from a department head that hadn't really, hadn't experienced in the past. So hopefully that will bear some fruit in the future. And I guess that's about it for on the
Mr.
record.
Chairman.
Mr. Owen?
We postponed a conversation on another matter, which is follow up on our letter.
Yes, yes.
I do want to thank you for taking the time to meet on our behalf.
Yeah, thank you for representing us.
My pleasure. One of the many benefits of retirement, or for the most part, retirement. Yeah, quasi-retirement. It is. It does make it be available at almost any time for those kinds of things.
Take advantage of it if you're going to skip out on this.
Yeah, I'm gonna.
Just make you meet with everybody and his wet dog between now and December.
Yep. Yeah. Well, March essentially. I'll have to.
Okay.
I have to.
Yeah, that's right.
I'll have to fulfill the term. And I guess that's it for the record. I think we can have some.
Just, it might as well be on the record to just ask if we could ask our secretary to talk to the county board's clerk to see if the county board is planning to give a response to our letter.
Yes, that would be. I
think it would be as simple as that.
I think can we consider that a resolution by unanimous consent to ask the staff?
I think you can just ask.
Yeah. Would you make a request of the county board's clerk to have some response to our letter, at least acknowledging receipt?
I will.
Thank you.
A substantive response would be even better.
Yeah, it would be even better.
An actual response, not just an acknowledgement of receipt.
That would be ideal. I start with the lowest. I try to get the camel's nose in the tent, and then I can.
With a little cat.
Yeah, then drag the rest of them in. Anything more? Okay, I'll take a motion to adjourn.
Move to adjourn.
By Ms. Malice, seconded by
Second.
Ms. Freshman. All in favor?
Aye.
Aye. All opposed? The ayes have it. The